We are here, ladies and gentlemen, because, thank you, Miss Quaneesha Johnson tried to right a wrong on her own terms. She pulled a gun and she pulled a trigger when there was no necessity. That is why we're here. That is what this boils down to. Mr. Sterling, in his opening statement, called this man a serial abuser 10, 15 times. But he does have a name. His name is Demonte Smith. He was a father. He was a son. He was a friend. And he was a member of the community. He had and has people who cared deeply about him. He wasn't perfect, but he didn't deserve to die. Like anyone else in this courtroom, he was not perfect. And like anyone else in this courtroom, Demonte Smith deserved an opportunity in his life to redeem himself of any of his faults. During jury selection, actually after jury selection and before the case began, you all took an oath before you heard any evidence in the case. And that oath was that you shall well and truly try the issue that is formed on the indictment of this case and give a true verdict according to the evidence. We asked a lot during jury selection whether you could be a fair and impartial juror, whether you could leave certain things outside from your decision in this case, whether you could focus on the evidence. So what is the evidence? Evidence here is any statements that you heard. Statements, previous statements, statements that come from that witness chair. Sworn testimony under oath is evidence. Evidence is any expert testimony. Evidence is you can determine or you can use your common sense when you're reviewing the evidence or you're determining what the evidence shows. Testimony of the witnesses, you can consider whether any of the witnesses that you heard from had a motive to lie. You can consider that when evaluating the testimony. Any photos, any documents that were admitted, the elements of the crime, consider that when you're deciding what the facts of the case are, applying it to the law. What is not evidence? Any passion about any issues or any facts in the case. Any public opinion about what happened in this case, about what should have happened in this case. Whether you are happy or unhappy with police in general, whether you are happy or unhappy with how the police handled this situation, that is not evidence. Any public feeling about any issues in the case, any sympathy for either party, for the victim or the defendant, any prejudice that you may have, whether you agree or whether you disagree with the law, and you are not, and you will hear from the judge to consider any possible penalty or judgment. Those things outside of that bubble should not come into play when you are evaluating what the evidence is and whether the evidence proves beyond a reasonable doubt the crimes that are charged. And we selected you because we thought that you all would be the most capable of doing that. We thought that you all would be the most capable of focusing on what's inside of that bubble and not letting the things on the outside influence your decision. So a couple things I want to discuss before we get into the evidence that you'll hear about, obviously. Reasonable doubt. We have the burden, the state has the burden to prove each element in each crime beyond a reasonable doubt. So what is it? The judge will tell you what a reasonable doubt is. She will tell you that it is a doubt of a fair-minded and impartial juror honestly seeking the truth. It's not beyond all doubt. It's not to a mathematical certainty, and it's not a doubt that's based on, it is a doubt that's based on common sense and reason. It's not a vague or arbitrary doubt. So if you have a doubt in your mind, is something possible? Maybe. But is it reasonable? If it's not a reasonable doubt, then it should not hold you back. This is the example that I oftentimes use to explain what reasonable doubt is. I am old enough to remember when people used actual paper money. So there were, if some of you remember, there were sometimes dollar bills in circulation which were really messed up. Like there will be writing on it. Sometimes it will have been torn in half and there would be like tape putting it back together. There might be a corner missing, scribbles all over it, right? But so it wasn't perfect, but you knew what it was and you would actually pass it at the store because you knew what it was. So if something's perfect, but did you have a reasonable doubt that that is a actual dollar bill? No, you didn't. And you would go to the store and you would pass it. It's much like this puzzle. So there's pieces missing. There's pieces missing. Is it perfect? No. But do you have any doubt, based on what you see in there, that that is a $1 bill? No, you don't. So it's not perfect, but you can still find that and you can still come to that decision. The other thing I want to talk about is credibility of witnesses. So when you're evaluating the evidence, you will have, one of your jobs is to determine the credibility of the witnesses who took the stand. This is no different. Your job of doing that as a juror is no different than it is in your daily lives. Because we do this as people every day, especially if you have kids, you do this. You have to evaluate the credibility of what they're saying. And what do? You're going to receive a jury instruction on how to evaluate the credibility of witnesses, and it's really no different than you do in your daily lives. You are to consider the manner of testifying. Whether the person has an interest or lack an interest in the case. Their means and opportunity of knowing the facts about which they testify. So, does the person who's testifying, how do they come off? How do they come off to you? Does the person have an interest or lack of interest? Do they have some sort of bias or motive? Do they have their own personal interest in that would influence what they say? Their means and opportunity of knowing the facts about which they testify. Were they there? Were they able to see what they're testifying about? The probability or improbability of their testimony. Does it even make sense? Their personal credibility as you observe it. That's your job and one of the most important jobs as a juror. So ultimately, ladies and gentlemen, you determine who is worthy of belief. The other thing I want to talk about is evidence. So the type of evidence. There's circumstantial evidence and there's direct evidence, and the judge will explain to you what those are. You'll receive an instruction. Direct evidence is testimony of a person with actual knowledge. Actual knowledge from something that they observed, something that they actually saw. Circumstantial evidence is a proof of a fact in circumstances that tend to prove or disprove something by inference. Okay, that's a really fancy way of basically saying you know something because you can piece it together. And the example that I always give is when we put gas in our car. So when you go to the gas station, you put the gas pump in your car. Can you see the gas actually going into your tank? No, you can't. But there are things that you can observe. You can, if you're holding the pump, you can feel it. You can oftentimes hear it. You can smell it. It may have dripped out before you put it into your car. You can, unfortunately, see the dollar signs go up, so you know you're being charged. When you get in your car, you turn it on, you see the arrow go to the full tank, or it goes fuller. And then maybe even later you can see from your card that you used that you were in fact charged. Based on all of these things, you can infer you got gas, even though you couldn't see it.
Prosecution's closing argument. We'll get a break, get you back to the courtroom for more right after this.
Tonight on Closing Arguments, you've heard of Florida man. What about Florida woman? A closer look at the female defendants of recent cases that have thrown a dark shadow on the Sunshine State. Plus, convicted BTK killer Dennis Rader, now the prime suspect in a decades-old unsolved case.
She was a missing person. She went missing from a laundromat.
We'll discuss these new developments with the sheriff overseeing the investigation.
Closing Arguments with Vinnie Politan, tonight at 8, 7 Central, only on Court TV.
Oak Street Health.
Welcome back to Court TV Live. We are watching the closing arguments in the self-defense or murder trial for Quaneesha Johnson. The mother of 4 says she shot her boyfriend, Demonte Smith, in self-defense. The prosecution disagrees, says it was murder. Let's go back into the courtroom right where we left off, the state's closing argument.
So, based on Miss Johnson's decision, based on her attempting to right a wrong on her own terms, her choice to pull a gun, and not just pull a gun, but pull a trigger when there was no necessity, these are the charges that she faces. I want to go through each one just generally. You will receive an instruction from the judge that actually gives you the elements of each crime. But before we talk about the evidence, I think it's important for you to know what you're listening for. So let's take charges 1 and 2. Charge 1 is malice murder. Essentially, the state needs to prove each of these elements beyond a reasonable doubt. 1, that Miss Johnson caused the death of Demonte Smith. She did so unlawfully and with malice aforethought. So naturally you need to know what is malice. We receive an instruction on that. Malice is not the dictionary version, the legal definition of malice is not the dictionary version or the layman's term that we would think, that we would use in our everyday lives. Malice, you will hear, is just an unlawful intent to kill. It's without justification, it's without excuse, and it's without mitigation. It is not ill will or hatred. it is just an unlawful intent to kill without justification, excuse, or mitigation. It can be expressed, before that, it actually can be formed in an instant. There is no requirement of premeditation, and motive is not required. Malice, that unlawful intent to kill without excuse or justification, you can find if it could be expressed, so there could be a deliberate intent to take a life. Okay, rarely we see this, but I am going to kill you. So some express indication, or it can be implied. Implied is when there is no significant provocation. There's no significant provocation, but the circumstances of the killing show an abandoned and malignant heart. What is an abandoned and malignant heart? Do the circumstances show that? When you're asking yourself whether there is malice here, you're asking yourself, okay, is it implied? Do the circumstances show an abandoned and malignant heart? That is an indifference, and you will hear an indifference to human life. And when you're determining whether that exists, you're looking at the defendant's conduct. You can look at the defendant's conduct before the shooting, during the incident, and after. And you know what I'm going to talk about here. Ask yourself whether there was an indifference to human life after she shot Demonte Smith, after he is screaming in pain, after he falls on the ground, when she says bye. State submits that shows an indifference to human life. The second is felony murder. Now, in Georgia, it's not like you see on TV, our murder statutes, our murder charges are not separated into first degree, second degree, third degree, like they are in a lot of places. We have malice murder, we have felony murder, we also have voluntary manslaughter, and we'll get to that in a moment. For felony murder, the state needs to show that the defendant caused the death of Demonte Smith and that she did so by committing another felony. And we'll get to that in a moment. This felony murder is regardless of whether she intended the death to occur. So there is no malice requirement here. It is just, did she cause the death of Demonte Smith, and did she do it by committing another felony? You will see in the indictment that the state charged felony murder based on the underlying aggravated assault. So by committing the crime of aggravated assault, she caused the death of Demonte Smith. And we'll get to aggravated assault in a moment, but you will receive an instruction that aggravated assault is a felony in the state of Georgia. So these are the questions you're asking yourself. Did she commit an aggravated assault? We'll submit to you, yes. Did she cause the death? Or did that aggravated assault directly cause or play a substantial part in causing the death? We will submit to you that yes. The other one I explained, you'll receive an instruction underneath the charges, and you'll see this on the verdict form, underneath the charges of malice murder and felony murder, you'll also have the consideration of a lesser included offense of voluntary manslaughter. So you will be permitted to, and you can find, you can convict the defendant of voluntary manslaughter if you find, beyond a reasonable doubt, that she caused the death of Demonte Smith under circumstances that would otherwise be murder. But the caveat, that she acted only because of a sudden, a violent, and an irresistible passion that resulted from serious provocation. Serious provocation, you will hear, is that provocation, it can't just be any provocation. It has to be sufficient to excite that sudden and violent and irresistible passion in a reasonable person. A reasonable person. And you will also receive an instruction that words alone, no matter how provoking, will never reduce the crime from murder to voluntary manslaughter. Charges 3 and 4 are aggravated assault, family violence. The state needs to show beyond a reasonable doubt that Ms. Johnson assaulted Demonte Smith, that she did so.
What do we think so far? The state's closing arguments. Remember, they get to go twice. They start, defense goes, and then they get the final word. We'll get a break in here and get you back in after this.
Tonight on Closing Arguments, you've heard of Florida man. What about Florida woman? A closer look at the female defendants of recent cases that have thrown a dark shadow on the Sunshine State. Plus, convicted BTK killer Dennis Rader, now the prime suspect in a decades-old unsolved case.
She was a missing person. She went missing from a laundromat.
We'll discuss these new developments with the sheriff overseeing the investigation.
Closing Arguments with Vinnie Politan tonight at 8, 7 Central, only on Court TV.
Welcome back. We're watching the closing arguments in the self-defense or murder case for Quaneesha Johnson in Georgia. She admits to shooting and killing Demonte Smith back in November of last year, but claims she shot him to protect herself. Prosecutors say no, it was murder. Let's go back into the courtroom now for more of the state's closing argument.
Weapon, in count 4, it is with an offensive weapon. I'll get to that in a moment. And that the two were living in the same household. So necessarily you need to know what is an assault. An assault is an attempt to cause a violent injury, or it's something that puts someone in a reasonable fear of receiving a violent injury. You will receive an instruction that a firearm is a deadly weapon, so that is count 3. We charge aggravated assault based on the deadly weapon of the firearm. And in count 4, you will receive an instruction that you can find her guilty of aggravated assault by using an offensive weapon, which you'll hear is a weapon when used, something that when used offensively is likely to cause serious bodily injury. And of course I'm speaking about the tire rod that Ms. Johnson admitted that she took upstairs and confronted the defendant with and tried to hit him with. Count 5 is possession of a firearm in the commission of a felony, which is self-explanatory, but it's a firearm on or within her reach and during the commission of a felony. We are alleging that she did possess a firearm during the commission of any one of the following felonies: malice murder, felony murder, and aggravated assaults, which were in counts 3 and 4. Charges 6 and 7 are cruelty to the children in the 3rd degree. The state needs to show that Ms. Johnson intentionally allowed a child under the age of 18 to witness a forcible felony. We listed the forcible felonies as all of those in the indictment: malice murder, felony murder, and the aggravated assaults in counts 3 and 4. And of course, those 2 children who are named in the indictment who support those charges are Nyla and Nuri Clark. Okay, so finally, right, because this is the issue in the case. So you have the charges, you have the elements, and you'll receive those. When can a person act in self-defense? That's the issue. You'll receive legal instructions on this as well. A person is justified in using force that is intended or likely to cause great bodily injury if, only if, that person reasonably believes that the force is necessary to prevent great bodily injury to himself or a third person. What is a reasonable belief? The standard is whether the circumstances would excite the fears of a reasonable person. So you're looking at the situation through the eyes of a reasonable person, not through the eyes of the defendant. So that the fear has to be reasonable. The fear of death or great bodily injury has to be reasonable. That reasonable belief has to be that deadly force is necessary, but also a claim of self-defense is not available to someone who is the initial aggressor. A person is not justified, and this is not a defense that is available to someone if the person provokes the threat or provokes the threat or the use of force against herself, if she is the initial aggressor, or if she is engaged in combat by agreement. So essentially there are limitations. You can't start something and then complain that, well, I felt like my life was in danger. The state is submitting that the facts in this case show that Ms. Johnson's belief, or the belief that Mr. Sterling will argue that her life was in danger, was unreasonable. That deadly force was unnecessary, and that she was the initial aggressor, or at least provoked use of force. And here are some of the reasons why. Mr. Sterling, in his opening, referenced several times about how seriously Ms. Johnson took these threats before she got home. And even when he questioned her, he asked her, why did you take these so seriously? I want to know. If she took them so seriously, then why in her first 911 call is she laughing? Why is she telling Detective Knight that when she first heard these threats, or when Demonte was saying these things to her, allegedly, that she, quote, was joking it off? That isn't someone who's taking it so seriously. Why then is she saying to 911 on the third call, quote, I'm not worried about my safety? But now here in court, it's, I was scared for my life. I was crying for the police not to leave. I thought my life was in danger. When minutes prior, she's telling 911, I'm not worried for my safety. She announces her intention. She announces her intention to the police. And by that, I mean she says to them, okay, when I shoot him, And the police tell her, Officer Lammy tells her, well, you know, you better be able to articulate that. And what was her response? If I could switch to it on there, I would right now. But I trust that you recall this. She says, oh, I can. Oh, I can articulate it. Ma'am, if you can't, how can you articulate the need to use deadly force when nothing has happened yet? She has decided she's going to do it. She has announced her intention, and she has decided beforehand that she is justified in using deadly force. That is not how it works. She walked in the house freely. She walked in the house freely. Mr. Sterling, I know, will talk about how she had no duty to retreat. I know that, and that is legal instruction that you will get. But the absence of those actions go to the reasonableness that her life was in danger. She walked in that house freely, on her own free will. Police were in front of the house because she had gone up to the police car and said, listen, you guys cannot leave. You can't. I am deathly afraid to go in my house. I need you to go in there. I need you to help me get my kids, and I need you to help me get somewhere. That is not what she did. So sure, she does not have a duty to retreat, but think about what she could have done if she was really, really that worried for her life. She prepared for a confrontation. She goes to her car. She gets the gun. She gets a tire rod. She goes in the house. She prepares for it. How does she do that? She tells her kids to put the dog up. Put the dog in the cage. She tells Detective Knight that she did that. I told them to put the dog up. I told them to stay downstairs. Why? Why did she do that? Because she was preparing for a confrontation that she was about to have with the defendant. And what does she do? She walks upstairs to Demonte. She knows he's upstairs. That's where he took the baby, to put the baby down. So she walks upstairs to where a place in the house where there is no exit, mind you. She has a tire rod in her hands. She has a gun in her pocket. And she is going to confront the person that she now says makes her scared for her life. And she knows that he's unarmed. I mean, quite frankly, in that situation, she's got the upper hand. She's got the gun. She knows he doesn't have one. And she got another weapon. And the cops are still outside. All of these things are what you should consider when you're thinking about whether this belief that her life was in danger and whether the need to use deadly force was absolutely necessary. These are the things that you should consider. And when you're questioning whether she provoked the use of force or whether she was the initial aggressor, these are facts that you should be considering. And I remember what she testified. She said, I was scared. She says, I was scared. But being just simply scared is not enough to pull the trigger of a gun. You can't just be scared. You have to be in real, reasonable fear that your life is in danger. In a moment, I'm going to leave the floor to Mr. Sterling. And like in his opening, I expect that he will talk about a lot of things. He will talk about a lot of things other than what happened upstairs at 796 Edenberry Lane on November 27th, 2022. He'll talk about a lot of things other than what the physical evidence shows. He's going to talk about the police, and he's going to talk about likely how awful Demonte Smith was, how awful he thinks he was. That's his case, I understand that. How awful the police were, and how awful the victim was here. But the thing is, and what I want you to remember, is that the police are not on trial. And neither is deceased Demonte Smith. What you are here to evaluate are the defendant's actions. In those moments that she pulled the gun, that she was walking upstairs to confront Demonte with 2 weapons, was she scared for her life? In the moment that she pulled that weapon, did she have a real fear that her life was in danger? Everything other than those critical few moments, I submit to you, is background noise. Everything that they have tried to throw in about Demonte Smith's background, it's background noise. Because none of it changes the fact what happened in that house that day. Self-defense laws, they are laws of last resort. Being just simply scared is not enough. The question for you is, was it Ms. Johnson's only option to save her life or save the life of someone else? Now, because the state has the burden, we will have another opportunity to speak, and at that time, when we do, we will address how the evidence does not support that. Thank you.
All right, the first part of the state's closing argument, we'll get a break and hear from Mr. Michael Sterling. What's the defense going to do to counter it? That's next.